whoa. Listen. You think that you thought? Hold on. We don't have evidence of that.
The real truth about it is when I really did quit claim this territory back in what it was 2001, and actually more recently. When I found out that they said would not transfer it, that's when I sued. But I didn't know that I didn't have to sue. So I sought help to teach me how to litigate.
Right.
I was taught how to litigate, and now I do know how to litigate.
Yes.
Thank God, because
yes.
I have a criminal case.
Yes.
And I don't have to be under the auspices of a lawyer who's going to say, you got to pay $250,000 because there's so many indictments. No. They don't even know what my situation is. They can't even help me. All they're going to do is escort me into confusion and into the jail. I know exactly what my situation is. No one can defend me like I can defend me. So I'm not worried about these criminal charges because they're fraudulent.
Yes.
There's no way a quitclaim of a nation for their property that is patented to them is a lien. It's not a lien.
Right. It can't be.
It can't be a lien. Not when you already own it. It was stolen and it belongs to you.
This transcript contains a mix of legal terminology, historical claims, and personal beliefs. Much of it misuses real legal concepts in ways that are not supported by U.S. property law or the historical record. Here's a strict fact check. Claim, accuracy, notes. Everything here is under our patent. False. Land patents exist, but they do not mean an entire modern region remains owned by one tribe or descendant forever. Patents last forever, generation to generation. Mostly false. A land patent is the original conveyance from the sovereign. It does not automatically create perpetual ownership regardless of later lawful transfers. When someone dies, the land automatically goes back to the Indians. False. Property passes according to probate, wills, trusts, tribal law, if applicable, or federal law. There is no general rule that patented land reverts to native nations. A deed is nothing compared to a patent. False. In modern U.S. property law, recorded deeds are the primary evidence of ownership. A historical patent is part of the chain of title, not a document that overrides every later conveyance. By filing a quitclaim and genealogy, I became the owner. False. Recording a quitclaim deed by yourself does not create ownership. A quitclaim only transfers whatever interest the grantor actually possesses. If the grantor owns nothing, nothing transfers. The county gave me an instrument number, therefore they accepted my ownership. False. Instrument numbers simply document that something was recorded. Recording is not validation of legal ownership. Government officials had no authority to reject my claim. Recording offices, courts, and title systems determine legal validity under state law. Recording alone does not establish title. The deed system is fake. False. The deed system is the recognized legal framework governing real property throughout the United States. I quitclaimed the property to the nation, not legally effective without ownership. If she did not already possess valid title, she could not legally convey the property to anyone else. Historical problems. The argument assumes all ancestral land patents remain legally enforceable today. Genealogy alone restores ownership. Counties are obligated to recognize historical patents over current deeds. Modern property law is illegitimate. None of these propositions are recognized by American courts. Throughout U.S. history, there have certainly been legitimate disputes over unlawful land takings, broken treaties, and tribal dispossession. Those disputes are generally addressed through treaty litigation, federal Indian law, congressional settlements, land claims commissions, negotiated settlements, or recognition of tribal sovereignty. They are not resolved simply by filing a quitclaim deed with the county recorder. Internal logic. Even within her own explanation, there are inconsistencies. She says she personally owned the park beginning in 2021, then transferred it to the tribe, but also says it always belonged to the tribe, while simultaneously claiming she never intended personal ownership. Those positions are difficult to reconcile. Use of legal terms. She repeatedly uses genuine legal vocabulary: patent, quitclaim, instrument number, title, deed, genealogy. The problem is not the words themselves. The problem is the meanings being assigned to them. They do not operate the way she describes under U.S. property law. Overall historical and legal grade. Historical accuracy, D. Legal accuracy, F. Use of legal sources, D. Logic and reasoning, D. Evidence, D. Overall grade, D. The underlying concern about native dispossession is rooted in a real historical issue. The United States has an extensive history of treaty violations and unlawful dispossession of indigenous peoples. However, the specific legal mechanism she describes, where a descendant can reclaim public land by filing a quitclaim deed supported by genealogy because of an ancestral patent, is not supported by American property law or by court precedent. That distinction is important. A real historical grievance does not make every proposed legal remedy valid.
Whoa, hold on. We don't have evidence of that.